Good morning. I'm Jane Fielding. I'm head of the Employment, Labour and Equalities team here at Gowling WLG in the UK, and I'm delighted to welcome you to the second of our series of 4 webinars when we take a mid-year look at what's going on in the world of employment law. Those of you who listened into our first webinar on Tuesday this week will have heard me say we really didn't expect to be doing these remotely a year after we did the last set last summer, but here we are and life goes on. And for us, that means that businesses are still being sold, services are still being outsourced, insourced, retendered, and we still get to advise on one of our favourite topics, which is TUPE. And judging by the fact there are 400 of you registered to listen in today for our webinar, it's topical for you as well, and you've been experiencing the same. So our topic today is achieving a smooth TUPE outsourcing. And obviously you need a good contract in the first place to rely on. You need to understand what's in it and be familiar with what tools you have in it. And then you need very effective planning from the outset. And our speaker today, who's going to put the flesh on the bones of all of those aspects of a successful outsourcing, is Hannah Swindle, who is a principal associate in our team. She's got 15 years experience, much of which she spent developing a real expertise in TUPE, and some of you on the call will have been guided through TUPE transfers by Hannah in the past. So Hannah is going to speak for about 25 minutes, and then we'll have 10 minutes at the end for questions, and we'll close the webinar at 11:40. If you want to ask a question, please can you use the Q&A function, which, if you're not familiar with Zoom, is in the bottom of your screen. If you ask a question, only Hannah and I and Lucy, who's helping us on the tech side, will be able to see the question. So don't worry about the fact it's not anonymous. Nobody else will be able to see it. We'll do our best to get through all of the questions, but if we don't get to yours, then don't worry, we will follow up afterwards with all the ones we haven't managed to talk about. And if you've got any tech issues during the webinar, which hopefully won't happen, then please also use the Q&A function, and Lucy will try to sort that out for you behind the scenes. And at the end, before we close, I'll just flag it again, but we do circulate after the webinar a feedback form. We'd be really grateful if you fill it in. It only takes a couple of minutes. We do read them, and we do use your ideas and feedback to generate future sessions. So I'll mention that again at the end, but I flagged it now, so you know to look out for it. And other than that, I think I've covered everything. So I will turn off my mic, go dark, and hand you over to Hannah.
Thank you, Jane, and good morning, everyone. As Jane said, I'm going to talk to you about outsourcing. I'm going to assume that this is a private sector outsourcing because there's lots of additional factors to consider when the outsourcing is within the public sector. For example, there are requirements about procurement that would need to be followed. So I'm going to go through an outsourcing process from the customer's side first, including what you need to consider when looking at the existing contract. Then I'll look at the supplier side, though of course the two are very much interconnected. I'll also touch on how a supplier might validly change terms and conditions of employment, because this often comes up after a transfer. And finally, I want to give everyone a quick heads up on 2 new cases which have been decided recently that have potentially significant effects. So I first want to look at where a customer is outsourcing services that it's currently providing for itself. It's really important that the customer plans the process in good time. It works out where it needs to get to, so there's enough time to put everything in place and deal with any potential issues that might arise. In every outsourcing, HR teams, legal and procurement or purchasing teams all need to work together, so they're joined up and nothing falls between the cracks. A first generation outsourcing, where there's a transfer from the customer of its own employees, should be simpler in many ways. The customer knows its own employees, what they do, so it should be able to easily identify who will be in scope to transfer. The customer's got to provide employee liability information about these employees 28 days before the transfer. But if you're inviting a supplier to tender a bid, you'll want to provide employee information a lot sooner, so they know who they might inherit and what their employee costs will look like, so they can give a much more accurate picture of their charges. Another part of planning is to make sure that the right people are retained to run the rest of the business after the transfer. If there are employees you need to keep, then there are a number of ways of ensuring they don't transfer, you'll usually need the employee's agreement. At the start of the process, you can move employees out of scope into other departments or onto different services. Or potentially you could keep employees in place until the transfer, but ask the employees to sign an opt-out, confirming they don't want to transfer and re-engaging them elsewhere in the business. Although a first generation transfer can be simpler in some ways, it can also throw up additional challenges that a customer needs to be alive to. Often employees are unhappy at being transferred out to a third-party company, so you need to be able to clearly explain why particular employees are in scope. Employees often complain that they've been unfairly targeted for a transfer when other colleagues haven't been included. So this highlights another reason to start the planning process early. It's important to allow enough time for effective consultation. This is key to smoothing any employee relations issues that might arise and helps to ensure services can be up and running effectively from day one. When an incoming employer has been identified, the customer will need to ask for their measures information, changes they propose to make post-transfer, and this makes up part of the information and consultation process. It's usually helpful to invite the incoming employer to speak directly to staff as part of consultation, and this can help resolve any issues the employees might have. So I want to look now at the contract that the customer is going to negotiate with the incoming supplier. The contract underpins the commercial relationship and context for the services and ensures that the customer and the supplier both have the protections and the rights they need. So I've set out on the slide what a customer is likely to be asked to include in relation to entry. Where TUPE applies, the employees transfer with all their existing rights and liabilities, therefore any pre-existing claims will transfer across. So the supplier will want indemnities or contractual protections to cover any liabilities which arose before the transfer. And they'll also want protection against any costs which might result from a failure of the customer to inform and consult. As TUPE applies to anyone assigned to the services, whether or not they've been included in a list of transferring employees, there could be employees who've not been identified previously but could still transfer unexpectedly. The supplier would then be on the hook for their salary costs to employ them going forward, or the cost of terminating their employment. Often a supplier is going to have costed a service taking into account a certain number of transferring employees. So if more transfer, this could wipe out any profit. So a supplier will often ask for protection against the risk of unexpected transferring employees as well. Here, we've only got employees coming from the customer's own workforce, so it's easier for the customer to be aware of any risks and provide these protections. And it's reasonable to protect the supplier from liabilities which result from its own actions. The customer is going to want some indemnity protections from the supplier as well, and they'll want to cover costs arising from a failure by the incoming employer to provide that measures information for consultation, any post-transfer liabilities, and also any liabilities that arise from the supplier's proposals to make post-transfer changes if they're to the employee's significant detriment or a substantial breach of contract. Because under TUPE, the employees have the right to resign and bring a claim as a result of these. So the customer will want to make sure the supplier is responsible for any costs that might result if the employees resign before the transfer. As with any contract, the context is always really important. If the supplier intends to subcontract the services, then the indemnities will also need to cover liabilities caused by subcontractors because they might inherit employees, or subcontractor employees could also be within the scope of a transfer on exit. And in turn, the supplier will want the indemnities it receives from the customer to cover liabilities that its subcontractors incur as well, because most likely it's going to be asked to stand behind these in its subcontract. If this is a second generation outsourcing with an existing supplier already in place, the customer should stay involved to manage the transfer, even though no one's coming directly from the customer, because it needs to ensure that its services continue without disruption. So who's going to transfer will impact the costs charged by the new supplier, and it's also important to ensure there's service continuity. There might be service critical employees that the customer wants to keep in place. And again, planning is really important. So first of all, the customer needs to check the existing contract. What rights does it have to ask the existing supplier for employee information and when? It needs to know which supplier employees might be in scope to transfer and what their terms are at an early stage of the procurement process. This will feed into both the new supplier's pricing and also negotiation of that new contract with the incoming supplier. It might take the supplier some time to mobilise, so the customer needs to allow enough time to receive the information after making the request. The customer will also want to check the information it receives. Sometimes the supplier might try and offload additional employees who haven't been working on the services. The customer might be able to use its own employees who manage the supplier service, who are on the ground, to verify what it's being told by the supplier. It's also helpful if the contract prevents the supplier moving employees out of scope of the transfer, offloading poor performers or expensive employees, or transferring employees' terms and conditions, so to give them perhaps generous termination payments, because everything is going to be inherited by the incoming employer under TUPE's automatic transfer principle. And that's why these provisions are often called anti-sabotage provisions, they're to try to prevent the outgoing supplier negatively impacting a competitor. Finally, as the employees are transferring from the existing supplier, not the customer has got to look at the indemnities it has in its existing contract and also what obligations it's subject to. And in the next slide, I'll go through what these might be. As a reminder, there's no direct contract between the suppliers, so all indemnities have to be flowed through the customer. The incoming supplier will ask for the same protections on entry as those we've just looked at when it's a first generation outsourcing. But here, as the employees are transferring from the existing supplier, the customer needs to check that it's got adequate indemnities in its existing supplier contracts, which protect both the customer and the incoming supplier, so it can pass these on. As the protections usually needed, the indemnities must cover the pre-transfer liabilities, any failure to inform and consult, and also to cover the costs from unexpected transferring employees. If there's a potential gap in the protection the customer has from the existing supplier and what the incoming supplier is asking for, the customer's got to weigh up the risk of giving that indemnity protection and not being able to pass it back, or possibly having the supplier price in any risk. And the context is key to working out that level of risk. How many employees are in scope to transfer? What's their profile? Do they all have long service, which means they have unfair dismissal rights, for example? Often it's better for the customer to give the indemnity and then have a contingent risk rather than have increased charges throughout the length of contract if it doesn't. The customer may also have given some protections to the existing supplier in the contract to cover its own acts and also those of any incoming supplier. So these will usually include a protection for a failure to provide that measures information, post-transfer liabilities, and also if any costs arise from proposals to make post-transfer changes. So it will need to make sure that it obtains these indemnities from the incoming supplier in the new contract for the benefit of itself and also the previous employer, so that it doesn't end up being responsible for the incoming supplier's acts or omissions. So if we now turn to look at things from the supplier side, when entering a contract, what does the supplier need to think about? It will be asked to provide pricing information to the customer, so it needs to know which employees are transferring from the existing supplier and what their salaries and benefits are. Pension rights especially can be really costly. The supplier's also got to work out whether it's got enough resource and skills to provide the services from day one, or if it needs to accrue, which can take some time. What does the supplier do if the employee information it receives is inaccurate? It might not be a problem necessarily if there's a straightforward pass-through of costs to the customer, but otherwise any increase in salary costs might wipe out profit. The supplier might be able to obtain a specific indemnity from the customer to cover losses, or alternatively, they might have to price in risk. Other options might be a charging adjustment mechanism once the employee information can be verified post-transfer. We've looked at the usual indemnities a supplier will typically need in relation to entry and also asked to give. But as other considerations, if the supplier is asked to restructure the services by a customer, then redundancy costs might also need to be taken into account for redundancies made in that period post-transfer. Often dealt with by way of an indemnity from the customer to cover or share the cost, or the supplier will need to build in those costs into the charges. So it's really important parties don't forget about the potential for TUPE on exit when negotiating the contract. They need to deal with it appropriately. I've mentioned the customer would want rights to ask the supplier to provide employee information on behalf of itself and any subcontractor at an early stage before termination. So the supplier needs to work out what information it can provide, in how much detail and how quickly. What it can agree might depend on how many employees work on the services and whether it's got the relevant rights in its subcontracts to require parties lower down the chain to provide this as well. A supplier is often asked to warrant the accuracy of information. Can it do that? It might feel comfortable doing this for its own employees, but maybe not for the information coming from its subcontractors. I've talked about anti-sabotage provisions, which prevent supplier changes to the workforce in the lead up to termination. Before agreeing, the supplier needs to make sure it's still got that sufficient flexibility to be able to run the services effectively and comply with its KPIs at all time up to exit. I've mentioned the types of indemnities that a supplier will be asked to give in relation to exit and will also need from the customer. As something else to think about, a supplier might also need redundancy cost protection to take into account a situation on exit where TUPE does not apply. Again here, context is really important. It's going to be a much bigger issue for the supplier if there are a large number of employees working on the services, or if it has taken on a large number of transferring employees on entry. So this again highlights the need to be joined up within the business. Often we've got the legal team negotiating contract terms. They'll need to be in contact with the business, with the HR teams to know the context of the services and what that employee risk is looking like, because this all governs what protections are essential or can be dropped and what obligations can be signed up to. The next one to highlight just a few useful tips to remember for the contract. So first of all, make sure the indemnities are wide enough in scope so the customer can pass protections onto a new supplier or back to the previous supplier and there's no gap. Does the customer want its suppliers to be able to enforce the protections directly instead of going through them? If so, then the suppliers need third-party rights because they're not a party to the contract, and this needs to be carved out of the third-party exclusion clause. Next, remember that TUPE applies to employees and workers. So any indemnity protection for unexpected transferring employees must cover anyone employed or engaged. Also, this type of indemnity only really works properly if you've got a list of transferring employees agreed, and the protection works to cover anyone outside of that list. Where TUPE doesn't apply on exit, because, for example, the services are coming to an end, the supplier will be responsible for redundancy costs unless indemnity protection has been given by the customer. A customer must also check whether any protection is given elsewhere in the contract. For example, wrapped up in any general employment charges or costs during the contract, or perhaps site closure charges, before deciding to take any specific approach on TUPE. Finally, don't forget about subcontractors if they're carrying out the services. Need to include them within the scope of protections from both the supplier and the customer. So next, I want to quickly look at a problem that suppliers often come across when they're inheriting employees on a transfer. Often, they're going to inherit employees with terms significantly different to their existing employees. It might want to then make some changes for a number of reasons. For example, the working patterns might not fit how the supplier runs its business, or because there might be potential equal pay issues going to arise. Employees have increased protection under TUPE in relation to terms and conditions, in relation to changing terms and conditions of employment. Even if employees agree to changes, changes can't be validly made and enforced at a later date by the employer unless they're unconnected with the transfer. So the changes affect the whole entire workforce, not just the transferring employees, or where if they're in connection with the transfer, there's an economic, technical, or organisational reason entailing changes in the workforce. Entailing changes in the workforce basically means a change in job function or numbers, so typically redundancies. So how would you handle this in practice? It might be possible for the employer to justify the changes with an ETO. The downside of this is that you need some changes in job functions or job losses, and often you don't want to reduce your workforce. And also, you won't have any certainty that a tribunal would agree with you that it's an ETO and enforce the change until the change was brought and that was all looked at. But it might be appropriate for an employer to use if there's no potential financial loss that employees can claim at a later date, because the risk of the change being unenforceable might then be lower. If it's essential that the employer has certainty around the change, then it can dismiss employees and re-engage them on the new terms. This must be handled carefully. It's got to be done under a settlement agreement, because otherwise any dismissal would be automatically unfair, because it's made by reason of the transfer. And also because you need to make sure you reduce the potential for employee relations issues. For non-TUPE changes, this method has been highlighted recently as being considered very heavy-handed. So you'd need to make sure that there was a very clear communication process and consultation with employees to know that this was being done administratively to ensure certainty. If you're going to be reducing, say, holiday entitlement or overtime payments, then this might be a way that you want to do it, because you don't want any financial loss to accrue, and then that claim could be made against you at a later date. Sometimes employers choose to buy out a benefit that employees have. This won't be enforceable if an employee wants to back out later, but you could get employees to sign an agreement that they repay the amounts they've received if they do choose to challenge it later, so that you're not left out of pocket if you have to unpick everything. If employers are putting together a package of changes, employees might not be so likely to challenge the individual terms later, but of course it is absolutely open for them to cherry pick the ones they want to keep. But of course, employees are less likely to raise an issue at a later date about beneficial changes, such as a pay rise. It's important to remember as an incoming employer that any changes you're proposing will be a measure. They need to be passed on to the outgoing employer so it can be included in the consultation process with employee representatives. And it's important for that incoming employer to get involved in the consultation process, if possible, so that you can speak directly to employees and try and iron out any issues that might come up from the proposed changes and get the employees buy-in if possible. There's also a risk that if employees don't like the proposed changes, they could resign and bring a claim, and that's under Regulation 4.9 or 4.11 of TUPE. They would have to be able to claim the change is substantial and to their material detriment or a fundamental breach of contract. And I've mentioned these protections earlier. TUPE gives the employees protection. The resignation would then be treated as a dismissal, and employees can claim it was automatically unfair. And I've mentioned earlier that usually this risk is covered by indemnity protection, and you usually see provisions in the contract to deal with that. Okay, so as I flagged at the start, we've had two recent decisions which have caused a bit of a stir in the employment world. I'm just going to give everyone a heads up today because we don't have time to go into this in detail, and it's still really unclear what the potential impact will be. The first was a European decision on the Acquired Rights Directive, ISS and GoVerts, in respect of a business transfer. And the second case was McTeer and Bennett in the Scottish EAT, looking at outsourcing under the UK service provision change provisions. GoVerts involved a cleaning business which was transferred to two transferees. An employee worked on both parts of the business, so the court was asked to decide how to deal with that employee's employment. The European Court decided that the employment could be split between the two transferees into two part-time contracts, and a split could be done either by looking at the time spent on the different parts of the business or their economic value. They did say that no split should be made if it's not possible, or if it caused a worsening of working conditions or adverse effect on the individual's rights. If that was the case, then the transferees would be responsible for any termination liabilities from an actual dismissal, or if the individual resigns and claims constructive dismissal because they don't like what's being proposed in relation to the split. But helpfully, the court didn't provide any guidance on how the employers were supposed to work this out, how to work out the split, or how to determine what would be a worsening of working conditions. They said it was for the national courts to decide how to organise it. UK law has always approached a transfer looking at whether an individual is assigned to the part of the business that transfers to either one of the transferees, or in service provision change cases, the courts have also held that the transferee that takes over the greater part of the transferred activities takes on the relevant employees of the transferor in certain cases. We've now had that second decision I mentioned, McTeer and Bennett in the EAT, which has moved the problem onto service provision change. Previously, the Coverts case related to business transfers, but now this second case has said that we should apply that principle to service provision changes. There are a lot of practical difficulties with splitting the contracts. How do you split it up fairly? How do you determine what's going to be adverse working conditions for the employees? What happens if there are many transferees? You know, that's going to be almost impossible to split a contract between 5 incoming suppliers. You'd have to manage the split in working hours. The employees might be asked to work in different locations. It might be the case that the transferees are competitors. So you've got employees working for 2 or more competing organisations, and they're going to have to manage that confidential information, for example. No one seems to be taking this decision into account in their drafting at the moment. I think everyone is waiting to see if it's going to be appealed. In the meantime, some potential ways that we might look to deal with this additional risk is to use obligations, warranties, indemnities in the services agreement. So, for example, on entry, a supplier is going to want certainty around who they're going to get, but also for how many working hours. They might expect a full-time employee, but if this principle is applied, they may only receive part of an employee's working hours. They might want to ask the customer to warrant the accuracy of the information they're receiving, for example. They also need to check that when they're getting the protection from unexpected employees, unexpected transferring employees, that applies to part of an employment contract as well as an entire employment contract. On exit, a customer is probably going to want to ask for a lot more detailed information about the supplier employees to check which part of the service each employee works on, so that if those services are split, they can have an idea of which employees will go where. They might also include an obligation on outgoing suppliers to reallocate the staff so that it's clearer where they sit in terms of the service lines, or perhaps to ask the supplier to help facilitate redundancies if there's going to be a risk the employees could be split between a number of incoming transferees, and it's better to manage a termination of employment rather than waiting for an employee to resign and trying to allocate liabilities accordingly. So just a quick heads up there on those new cases. We will be watching and waiting to see what's going to happen with those, and we'll update you on those as soon as we can. So now we have some time for some questions.
Anna, and we've had a few coming through, which I've been keeping an eye on, so we'll try to get through as many as we can. Firstly, you mentioned just there, actually, in the context of talking about those 2 new cases, that the incoming employer might need to make redundancies. If that is the case and the new provider wants to do that, can redundancy consultation start before transfer, is the question?
There are a couple of points to think about here, because the incoming employer can only fairly make dismissals after it becomes the employer, because of the enhanced protections TUPE gives employees around dismissals, and that will apply to the employees where they've got 2 or more years service. The outgoing employer can't borrow the incoming employer's redundancy reason. You've got to have that ETO reason to make a dismissal. So any dismissals made by the outgoing employer will be automatically unfair, and the incoming employer will inherit all the liability for them. The incoming employer doesn't employ the employees until the transfer. So even if it's going to make the dismissals after the transfer, any individual consultation it carries out before the transfer is also not technically going to count towards that consultation for dismissal purposes. And employers, as you know, got to carry out a fair consultation before making a redundancy dismissal. The situation is different where we've got collective redundancy consultation. So that's triggered if there's 20 or more proposed dismissals made by the employer in the same establishment within 90 days. If it is triggered, we've got additional obligations for the employer, and there needs to be a minimum period of 30 days or 45 days if more than 100 employees are affected before any dismissals take effect. So there are now special statutory provisions in place which permit pre-transfer collective consultation if certain conditions are met. So that can start before the transfer, which is really helpful because you've got that long time period before you can actually make dismissals. It's the incoming employer's process, but it's reliant on the outgoing employer to allow access to the employees and help elect any reps, for example. So it can be really complicated in practice. It's essential you've got cooperation between the parties. You're usually going to ask the parties to enter into an agreement to try and agree where potential liabilities sit. It is possible for the incoming employer to make dismissals before the transfer if it is really needed, but you've got to deal with that unfair dismissal risk that I mentioned earlier. So usually you'd ask the employees to enter into settlement agreements. Just as a quick reminder as well, if you are going to make those redundancies post-transfer, that's going to be a measure. So you need to feed that into the information and consultation process.
Sure. Okay. I think the next question also comes from that Govertz and McTeer cases actually, and to some extent you covered it, but I'll ask it anyway because it's an interesting topic for everyone. If the services are being split between lots of different suppliers, will TUPE still apply?
It's always very difficult to determine with certainty. It's going to really depend on the factual situation for any case. But the UK position has always been that TUPE can apply where there are different suppliers appointed. But if the activities are split between lots of different suppliers, it's going to be increasingly difficult to identify that service provision change. If you can't say with any certainty where any relevant activities have ended up and it's all allocated in an ad hoc way, for example, then TUPE is unlikely to apply. But if a large percentage of activities end up with one particular supplier, even if you've got others appointed, then you could get a service provision change transfer to that supplier of all the staff. Or if you've got distinct groups of employees which can be shown to correspond with the split in services to each different supplier appointed, then the employees can also be transferred along those lines. But those two recent cases could mean that we have a big significant change to what we understand the position to be. So we're going to have to take that into account as well.
Yeah, there's a comment here and a question. The comment is the rules around roles being split seem completely impractical, as you said. Were concerns expressed by industry at the time the rules changed, and has there been commentary since that suggests this may be revisited? Well, I mean, it was case law, so there wasn't an opportunity to comment in advance, although I'm sure these concerns did come up in the arguments, and there's certainly been commentary since that it's impractical. But as you said, I think we're just waiting to see if they appeal it, aren't we? But they must be getting close to their time limit by now.
Yeah, we haven't heard anything yet, have we? So it does remain to be seen how everyone chooses to deal with this. And as I said, we haven't seen any indication that any parties are taking this into account at the moment and in drafting. So yeah, we'll just have to wait and see.
Sure. So next question is a bit of a different angle on all of this. What happens if the supplier is insolvent? Does this prevent TUPE applying? And I assume from that it means the incumbent supplier.
Yeah, so here, if your existing supplier's gone bump and you need to get someone else in to provide the services for you, the key question is what type of insolvency process the existing supplier's entered into. In brief, if I just talk about the two main types of insolvency process, if you've got an administration, even a pre-pack, the automatic transfer principle of TUPE will still apply. So anyone coming in to take over those services will inherit the staff, but as the outgoing supplier is insolvent, they're not going to get any of those indemnity protections to cover pre-existing liabilities. So that could be very difficult. There could be wage arrears and things like that, for example. Often a customer in those circumstances is asked to stand behind that risk. And it might have to agree if it needs those services to continue and it doesn't have a choice. On the flip side, if you've got a compulsory liquidation, there's not going to be an automatic transfer of employees. So if you get an incoming supplier taking over the services, they can choose whether to take on the staff of the existing supplier and they won't inherit any liabilities. So in some ways that can be more helpful. But we have done a recent webinar on this as well, if anyone is interested and wants to look at the position in insolvency and employment law in more detail.
Sure, I think it's still on our website actually, isn't it? So yeah, okay. So there's a couple of questions here around employee liability information.
Mm-hmm.
So one is the question around what are the data protection implications of providing that, particularly sensitive personal data or special category data, as we're now supposed to call it, aren't we? And at what stage of the transaction that should be shared and anonymously.
Mm-hmm.
And then the second question is more around a timing one. So ELI has to be provided 28 days before the transfer. But the question is saying, aren't there some special circumstances where you can give that later? And what are they, if any? Did you want to pick up the first one on data protection?
Yeah, absolutely. So yes, I mean, we're all subject to very stringent data protection requirements now. So I've talked about employee information being shared at an early stage so that everyone can plan the process, plan the pricing, know what costs are involved. This will all have to be provided on an anonymous basis, and it has to be properly anonymized. So you can't just take out employee names when it's very clear there's only one person in one role and can be identified perhaps by a search on the website. Ideally, you would group data or give age ranges, for example, anything to make sure that that information is properly anonymized. But you need enough detail for the supplier to work out costs, and it's always going to be a balancing act to do that. Once you share information, you would want to ensure there's appropriate confidentiality obligations and requirements on whoever's receiving that information to keep it safe. If you're handling data, you've got an obligation to ensure that. Once we hit ELI timescale, so 28 days before the transfer, then because this information, which includes names and ages of employees, because it is required by TUPE, then that is a carve out, just a clear carve out from data protection requirements, and can be shared. And it should be kept updated so that if anything changes prior to the transfer, then that is all shared with the incoming employer. So you're safe. Once you hit that 28 days and you've got an identified incoming employer, you're protected.
Sure. So the special circumstances question, we traditionally, whenever special circumstances are mentioned, say, forget about that because you're never going to be able to bring yourself into it. But I think in the case of ELI, I suppose the one I was thinking about as this question came through was, if, and it would be unusual, but if somebody were assigned to the services, between the 28th day before the transfer and the transfer, then if you were going to maintain the argument that they were assigned, you should be consistent with that and provide employee liability information for them. But can you think of any other special circumstances? I mean, insolvency, would that?
Yeah, absolutely. An insolvency situation would definitely give rise to quick transfers where you don't have that 28-day period before the incoming employer takes over. And quite often, contracts for services are going to have step-in rights. So a customer needs the ability to step straight in and keep services going, even if the supplier does, fundamentally breaches the contract or goes insolvent. And so when the customer takes those over, that's also going to be an immediate transfer where you don't have 28 days to do so. And as you said, if people move in and out of scope, then you have to keep that employee information refreshed. It's not just static at the date 28 days before the transfer. You've got to make sure that it's kept updated and applies to everyone in scope.
Okay, and then we've got one final question, which is the $1 million question, really. on a service transfer out of a business, who has the final say on whether the employees are in scope of TUPE or not? I mean, that's the employment tribunal ultimately if it gets challenged, but that's why we spend such a lot of time trying to work out who is assigned properly, and then that becomes a negotiating point sometimes, doesn't it?
Yeah, exactly. And there's always practical difficulties in challenging information because you can't see behind the veil that the supplier is giving you. And it's just using all the resources that you have, your employees on the ground, have those people that the supplier is saying are on the services, have they been turning up to work? Or difficult, now we're working from home, but we might be back into facilities. And I think one piece of advice that a colleague gave me is that if there really is a dispute, it's quite often good to get the parties together in face if possible, but obviously over Zoom if not, to actually question why one side is saying a party's in scope and why the other's not. And then face to face, it's often very difficult to maintain any of that sort of artifice, and you have to give over more detail.
Yeah, great. Okay, well, our time is up today. Thank you very much, Hannah, and thank you to all of you for joining and for those very interesting questions. As I mentioned, you will, after the webinar, get emailed a questionnaire. Do please take a couple of minutes to fill that in and send it back to us, and we'll use that going forward. If we didn't get to your question, we did have a couple left over which we couldn't fit in, and we will come back to you by email separately. And otherwise, I hope to see you at our next webinar, which is next Tuesday, same time, 11 o'clock, where we'll be taking a closer look at how to do an effective investigation. So thanks again for joining, and have a good rest of the day.
Thank you.